Knowing our liability and student records, rights and responsibilities is very important for any school district, and I feel like it is really important that everyone know our FERPA rights and all of that. And I don't think that this has been done in our school, and I feel like this is important for teachers, staff, everyone to know what our rights and responsibilities are. So everything you need to know about student records will be covered in this presentation. FERPA stands for Family Education Rights and Privacy Act, and that is what is FERPA. I included a video here, just a short video clip to show you kind of what FERPA is about to begin with before we begin our presentation. Just a little background, fun little animation.
The Family Educational Rights and Privacy Act was passed in 1974 to protect students' rights. Education records are any records related to the student with some exceptions. Directory information is information not considered harmful or an invasion of privacy if disclosed. Students have these 5 basic rights according to FERPA. Education officials may release the directory information shown here. They may never release this information. Students must sign a written consent to release educational information except in these instances. Please refer to the PowerPoint presentation for a more detailed overview of FERPA regulations.
So Public Law 93-380 is the federal law that protects the privacy of student education records. This is also known as the Buckley Amendment of 1974. And under this, parents are given certain rights to view their child's education records. And once a child turns 18 or is enrolled in a post-secondary education college, that child has the right to his or her own educational record. Our school responsibilities are basically that we should report to parents on an annual basis any information about FERPA laws and parental rights concerning their educational records. And such rights for their parents include the right to inspect and review their education records, the right to seek amendment of records believed to be inaccurate, misleading, or in violation of the student's privacy. And this PowerPoint will also go into what happens if a parent feels like something is in the educational record that is not correct or is not accurate. Our responsibilities as a school also include consenting to disclose personally identifiable information contained in the student's records, and also right to file with the department complaint concerning failures of the education or institution to comply with the Buckley Act, also known as the FERPA Amendment. Additional information in an annual notification could also include procedures for their rights to inspect and review their educational records of their students, requests for amendments to the records, and specific criteria for determining who is a school official and what is a legitimate, what constitutes a legitimate educational interest. No school employee can look at a student's records without a legitimate educational interest. They can't just get into the record because they want to. What should be contained in education records and what should not be contained are listed in this chart. Education records should include records, files, documents, and other material that is any information that relates to a student or is maintained by the education agency, institution, or a person acting for an agency or institution. Some things that should not be included in the educational records are instructional records, supervisory records, or records maintained by law enforcement units for law enforcement purposes. They should not be contained in that. That would be a completely separate concern. or any records on an 18-year-old student attending a post-secondary institution, anything maintained by a physician, psychiatrist, psychologist, or other recognized professional involved in the treatment of the student. And a little later on, I will get into what are the rights and responsibilities of a school counselor as well, which is part of this piece. I found this and I just thought it was a funny cartoon pertaining to how we kind of view student records, and yeah, just a funny little thing. Information that may be released. A school district may release directory information, such as child's name, address, telephone number, date and place of birth, participation in extracurricular activities, weight, height, and membership on athletic teams, dates of attendance, and diploma and awards received. But nothing else can be contained with or released to the public. Parents' rights. Legal guardians, they both have the right to inspect their child's records. School officials have to be present to assist the parent or guardian in case they have any questions about anything that's contained in the record, or just in case they want to challenge something. And they can challenge the accuracy of a record if they feel like something is not correct. The procedures for challenging. A conference must be set up within 10 days. The law actually says no more than 45 days of initial challenge for discussion, and if an agreement is reached, then no further action is needed. However, if an agreement is not reached, then a hearing with the director of pupil personnel must be scheduled within 10 days, and a parent or guardian may have legal counsel present at that time. If the school official hearing decides that the information is correct, then the parent must be informed and provided an opportunity to place a statement or a disagreement in the file, and it has to contain reasons for the disagreement. Statements then become a permanent part of the record and must be disclosed when records are released. And a parent or guardian may seek relief in civil court if they feel like the rights have been further violated. Release of student records may only happen with written consent forms. Permission has to be obtained by parents, guardians, or eligible students or other school officials. For example, transfers to another school district those records can only be released to an official in that school district, not anyone else. And if it's a telephone release, those are really difficult to do because you don't always know if the personnel on the other end of the line is actually the person that should receive the records or not. So it should be something very official, sent by mail or in some cases now email. Rights of school personnel. Teachers, counselors, and administrators who have a legitimate educational interest in viewing a student's records may do so, but only if it's a legitimate education interest. Teachers shouldn't be looking in kids' records or student records just to be nosy. There should be a reason for that. And with that, a written form should be included that indicates specifically which files were viewed by student personnel and the date of review, and any types of information that was obtained. U.S. Supreme Court ruling on February 19th, 2002 in the Owasso ISD v. Falvo case. Their ruling was that peer grading does not violate FERPA. And this is something that is always contested or always looked at in schools, is if it's okay for students to peer edit, peer grade each other's papers. And in this ruling, it is okay for that to happen. Our school personnel responsibilities include that a teacher cannot communicate to an unauthorized person personal or sensitive information about a student that will cause injury to a student's reputation or that it is disrespectful. And there are two ways that this can happen, either through slander or from what we know as libel. And slander is oral defamation of character, and that occurs when a school personnel, teacher, whoever communicates very sensitive or very damaging information contained in a student file to those who do not need to be informed of this information. Libel is written defamation of character, anything that is written down, any information that is damaging or has no basis in fact, and that should not be a part of a student's education record anyway. Only information that's factual and specific or serious in nature with date, time, and witnesses should be included in a student's record. School counselors, communication between a school counselor and a student are confidential unless it is required as testimony in court, or if a child might cause a threat to himself or others. The bottom line is this. School districts have a legal obligation to follow FERPA requirements. We know this. School districts should communicate these rights to parents annually. Education records must be accurate and maintained, including those who view them. And school personnel have an ethical obligation of good faith that does not harm a student. Teachers should also not participate in any chatter regarding confidential information about students. Education records must remain safe and secure. The releasing of school records should only occur to authorized personnel, and any violations to the FERPA Act is subject to the law and can result in court proceedings. And we really don't need that to happen. And I just found this kind of interesting as well. I have your school record, and I couldn't help noticing that you chewed gum and were tardy and often disruptive in first grade. And we just don't need to contain that kind of information in a student record. It isn't pertinent to anyone. In my school, USD 494, annual notice is provided to parents regarding the FERPA Act. The student handbook also contains information regarding school records, and that is viewable all the time. Records are viewed only by authorized personnel with a valid educational reason, and records for transfer students are handled only by authorized personnel, no one else. And here were the resources that I used. Our textbook, Teacher's Guide to School Law, and then the United States Department of Education Policy on Family Education and Privacy Act.